My name is, wait, sorry, let me just start the time. Okay, may it please the court, my name is Jimmy McCulloch and I represent the appellant Louise Ewens. It is the belief of my colleagues and I that the defense that Mr. Ewens has been sentenced to murder unjustly, and this should be rectified to a sentence of manslaughter based on the facts of this case. The basis of this belief relies on the three principles of the Coroners and Justice Act of 2009, which established the means to reduce sentences to manslaughter, as I'm sure my learned friends are familiar with. These are A, loss of self-control, B, a qualifying trigger, and C, the degree of tolerance and self-restraint. Beginning with Mr. Ewens' loss of self-control, there was a moment confirmed by the facts of the case and with the defendant's own testimony where he blacked out during the killing of the victim, Geoff Carter. This shows a lack of knowledge of his own actions and their consequences, as there seemed to be some memory loss out of shock of the victim-initiated violence, where he had firstly flicked a jelly bean at the appellant and his brother. Then the brother was struck by a rock, causing graze on his neck, as confirmed in the witness testimony. And to go along with these actions, the victim made salacious comments to the defendant, displaying a repeated and consistent verbal and physical abuse. The victim also had the willingness to start the fight, as confirmed by his partner, Susan Christopher's statement, as well as being able to take care of himself, showing he is known to be violent and he reacted aggressively. This would again confirm that he initiated the violence and therefore puts Mr. Ewens in a self-defensive position. The defining characteristics of a loss of self-control is that it's temporary, as seen in the case. Although the momentary blackout caused by the confrontation ended in a tragic death, afterwards the defendant called the police immediately to try and save the dying victim who had been stabbed in the commotion. This tells us two things about the defendant. One, that he had no intent to kill the victim, hence the mens rea and the actus rea could not have met, which is essential to make the defendant liable. So because the mens rea was not present at the time of action, the killing, this clearly defines this case as one of voluntary manslaughter and shows his loss of self-control shortly after regaining control. Shortly after regaining control, the defendant immediately informed the appropriate authorities, who arrived within 34 seconds, as stated by the responding police constable. Secondly, this tells us that the defendant was extremely remorseful and had no intention of escaping or evading justice because of his crime, which I implore her ladyship to consider for this case in terms of reducing the appellant's sentence, and once again proves lack of intent from Mr. Ewens. An experienced police constable, R. Payne, also confirmed upon his arrival to the incident that Mr. Ewens was stood still in shock and recalled him saying he's gone in disbelief of the death, therefore confirming again a lack of intention to kill. In the case that created the precedents for this section of the Act was Regina v. Duffy. As highlighted by Judge Devlin J. in the Duffy case, the abuse acted upon the defendant could have been physical or verbal to qualify that person for loss of self-control, as in this instance where the victim verbally abused Mr. Ewens in a salacious manner and physically abused him and his family, putting them both in a sense of danger. The second part to this defense of Mr. Ewens is the qualifying trigger created by the victim, Geoff Carter. This relates to the things said, done, or said, which were listed previously, which must cause a justifiable sense of being seriously wronged. I think it's inherently obvious that Mr. Ewens was seriously wronged by the victim, and any reasonable person in the same position would have reacted in a similar way. Because the defendant was continuously and repeatedly harassed by the victim, it led him to experience a loss of self-control while defending himself from his attackers, resulting in the death of the victim. And to support this argument, my associate will elaborate on the cases involved in the precedents that made up this section of the Act.
May it please the court, my name is Aya Thabit and I represent the appellant Louise Ewens. With reference to the case Regina versus Dawes, the defendant was attacked with a bottle when he found himself next to a knife that fatally injured the victim. Similarly, our client found himself in a position of grave danger and acted on instinct. There was no prior motive to kill. The judge held that the defense of loss of self-control could not be put to the jury under section 55(6)(a), as he had incited the violence. However, in this case, the violence was incited and interactions were initiated by Carter, both physical and verbal. He was convicted of murder and appealed, contending the defense of loss of self-control should have been put to the jury. He was appealed like our defendant for a misjudgment. We're also using the case Regina versus Boyer as part of our defense. The defendant in this case did not have any grudge prior to the attack, nor did he intend to kill Soller. This is similar to our defendant, as he did not claim to have any intentions to kill or harm the victim, proven as they did not have any prior interactions and were strangers, eliminating mens rea, vital in convicting for murder. Furthermore, the defendants in both cases had been taunted by the other through the use of sexual comments. The defendant in this case had gone to burgle Soller but had no intention of harming him. A fight began where Boyer told Soller that his partner was a prostitute. This was a qualifying trigger. In both cases, the defendants had qualifying triggers. This led to the defendant reacting in a similar way and caused a loss of self-control. In the heat of the moment, the defendants acted as most people would. Neither had intent to harm the other prior to the qualifying trigger. The degree of tolerance and self-restraint requires a person of the defendant's sex and age with a normal degree of tolerance and self-restraint, and in the circumstances of the defendant might have reacted in the same or similar way. The law states that a trigger event must occur where the victim is in a position of fear or serious violence. As shown in the facts of this case, clear signs of provocation are demonstrated, as the defendant's brother was struck on the back of the head when they attempted to walk away from Carter and his group. The defendant and his brother were continuing north on Carnaby Street, making an effort to disregard mocking and unmannerly remarks from Carter and his companions. The defense had no previous relationship with Carter and were simply intending to enjoy a simple night out. Had it not been for the interaction that the prosecution initiated, we would not be in this situation. Our client had no reason to converse with the prosecution, nor had any rationale in initiating contact. Carter initiated conversation with the defense, asking if he wanted candy, and then proceeded to flick a jelly bean towards them, as confirmed by John Sellers, first cousin to the victim. After the defendant and his brother ignored them, Carter's group began throwing salacious comments at them. Whilst trying to walk past the group, the accused brother, Andy Ewens, stated that he felt something thrown to his neck and grazed him. As clearly shown, this act portrays that the victim was first to commence physical violence. The law states that a trigger event must occur where the victim is in a position of fear, hence the defendant acting in self-defense, asking why the victim had done this. The victim responds in an aggressive manner, saying, "Do you want a jelly bean, you crybaby?" Persistence to make interaction is plainly indicated from the victim and his gang. Sexual infidelity is a factor and a qualifying trigger, and although it is not enough to validate the defense, paired with loss of self-control and self-defense, it creates a viable defense for manslaughter. The victim was using suggestive comments toward the defendant, implying he would be unloyal towards his partner and that he was homosexual. Similar to the case of Regina versus Clinton, Clinton was provoked to an act of killing on the grounds of sexual infidelity. And although Clinton was charged with murder, this was because he solely relied on sexual infidelity as a defense. Nevertheless, the events of this case demonstrate obvious signs of the victim abusing our client's self-restraint, in which anyone with a normal degree of tolerance, as stated in the law, would have reacted similarly. As mentioned in the facts of this case, there were several others standing around, and the victim's long-lasting girlfriend stated that her partner turned around and reacted back aggressively through his body language, shrugging his arms towards the accused, displaying a willingness to engage in a physical breakout. The defendant's next memory was when he came to with a man on top of him and a man kicking him. Our client awoke to a knife viciously being waved in front of his face, causing extreme panic and horror to the defendant. Clearly outnumbered, this places the defendant in a position of serious violence. Our client was in a violent altercation with the victim, and as shown by the witness testimonies, he feared for his life. The defendant was put in a situation of life or death, caused to act in self-defense to save his life. In accordance with the law, this warrants a self-defense in the perspective of the defendant.